didn't we have any such regulations, any regulatory body dealing with insolvency of the corporates? Obviously not. That is not the case. There were almost 20 to 30 legislations, but then in a very scattered form, where they dealt about the insolvency procedures of the corporate firms in India. Obviously, lot of lacunae existed, mainly dealing with the time process. Why again time was a big concern? Because it is all about the assets. It is all about the valuation of the assets. So time is again one of the important factors to be dealt with respect to the capital, with respect to the assets of the companies in India and abroad also. So even if the assets were undergoing insolvency, if insolvency process was initiated, that was not completed within a time period. So that was the major difficulty being faced, because of which the companies ultimately had to be liquidated. Now, liquidation is not something we want or any company would want. So the committees sat, deliberated upon, and majorly it was the Vishwanathan Committee, which is also known by the name Bankruptcy Law Reform Committee, BLRC, which had put on the efforts to come up with this legislation. And whatever is there in the report, that is the BLRC report, excepting a few things, majorly the enactment deals with all the deliberations made by the committee, Vishwanathan Committee. So if you deal with, or if you go through the very first para, which is said to be the preamble of the legislation, it actually covers the entire thing. That is, what is dealt under the code. Obviously, it is a process. That is why it is said as corporate insolvency resolution process. But then, why the process is to be done? And one thing that need to be observed is it is IBC. It is not IBA. So it is Insolvency and Bankruptcy Code. It is not an act. So why not an act and why a code? Obviously, the law graduates are aware of this fact that code is again complete in itself. We need not look here and there. We need not go through any other material if everything is provided under one head. So that is the importance of code. Just like we had IPC, Indian Penal Code, it is complete in itself. So that is why the name of this enactment also is Insolvency and Bankruptcy Code. So majorly, when you look into or scroll into the code, you will find that the code is divided into basically two parts. One dealing with the insolvency process and the other one dealing with the bankruptcy. So insolvency, majorly the first part is again dealing with the insolvency. Insolvency of whom? Insolvency of the corporate persons. Insolvency of the partnership firms. Whereas the second part, if you look into, it deals with the bankruptcy. Bankruptcy of whom? Bankruptcy of the individuals. Bankruptcy of the LLPs, limited liability partnership firms. Again, one question might come into your mind that till date, we don't find any bankruptcy issue moving on to the courts. So why is it that? Because the second part of the code is still not into force. there are many reasons because of which it is not into force. That is again a subject in itself. But basically, the first part that deals with the corporates, that deals with the insolvency resolution process of the corporate persons. Now, if you look into the very first part, that is what I was stating, was that is the preamble of the code. It summarizes the entire thing. What would have been the intention of the legislature while enacting this code? It states an act to consolidate and amend the laws relating to reorganization and insolvency resolution process of corporate persons, partnership firms, individuals in a time-bound manner for maximization of the value of assets of such persons. So here I stop again. In a time-bound manner. Why time-bound manner? That is also answered, that is for the maximization of the valuation of the assets. Why do we want to maximize the value of the assets? So that the company, which is a going concern company, mind it, there is a difference between a sick company and a going concern company. So when it is a going concern company, obviously it needs time, it needs opportunity, it needs an effort from outsiders so that given a chance, they would again revive back. So again, if the entire CIRP is completed within a time slot, then obviously it would get the opportunity to revive back. That is why under the code, if you look into section 12, it talks about the time period which is 180 days. 180 days is the time period within which the entire CIRP has to be completed. However, 90 days more are provided so that if at all any company, any corporate person would not have completed the CIRP in 180 days, then again 90 days would be provided to them. So near about 220 days are provided, and obviously there have been amendments, there have been judicial reviews where many reasons are provided, and ultimately for those corporate persons which could not complete the entire CIRP within a time slot of 220 days now are given a maximum time period of 330 days. So you can look into the case of Swiss Ribbons versus Union of India and the Committee of Creditors of SR Steel versus Satish Kumar Gupta, wherein you can very well understand that why again the time period is important for a company to adhere to. So basically, here, when I was reading the very preamble of the code, one thing that again need to be observed is that they are talking about the reorganization of the company. Mind it, the ultimate aim and objective of IBC is to reorganize the company, is to rehabilitate the company, is to revive the company back, is to bring the company on its own feet, stand again. Whereas if we talk about the earlier laws, that is SICA, Sikh Industrial Companies Act, if we talk about SARFACI, if we talk about the Companies Act, be it of 1956 or 2013, even if we talk about the RDDBFI, if we talk about the Provincial Insolvency Act, if we talk about the Presidency Insolvency Act, right? These were the laws which were prevalent, some of which have been repealed as of now. Some are still existing with modifications. So there, the major lacunae because of which insolvency could not be successful and because of which a new code had to be enacted was majorly because the time was not the essence of insolvency. Whereas here, time is said to be the essence of insolvency. So here, the main objective, the main aim of IBC is the revival of the company and not to liquidate the company. If you look into the contents of the Companies Act of 2013 or even 1956, you will find the last few chapters dealing with the winding up of a company, liquidation being one of the mode. So there, the stress has never been into reorganization of the company. The company is obviously established with a lot of futuristic ideas, but if the company is not doing well, if the company or company's liabilities are more than the assets, then they want to exit the market. The promoters, the stakeholders of the company would like to exit from the market. So once they want to exit from the market, it is very easy to shut down the company, to close the doors and get back to home. But what is important under IBC is that we don't want to shut down the company. We don't want liquidation. What we want that the company, through the efforts under CIRP, again revives back, again reorganizes. So that is again said to be the main essence, the aim and objective of this code. So the entire process, when you look into, you will find that there have been a lot of effort by all the stakeholders, by the resolution professionals, insolvency resolution professionals. There have been effort by the committee of creditors. There have been effort by the corporate debtor himself to revive the company back. So one thing again, which have been taken care of by the legislators while enacting the code, was easy entry and easy exit from the market. So easy entry, again, if you look into the preamble of the code, you will find after time bound manner for maximization of value of assets of such persons, it is stated to promote entrepreneurship. Now, how will entrepreneurship be promoted? We are now in a globalized world. We want to make our relations with international bodies more stronger. For that, we need trade. So, how will that trade be strengthened? How will that trade develop? Obviously, when we promote entrepreneurship. So, how will we promote entrepreneurship? Only when the fear will disappear from our minds. So, how will the fear disappear from the minds? When the law provides that guarantee to the stakeholders that fine, you enter the business world. If at all you do well, if profits are earned, fine with that. But then if you face problem and difficulties, if you are not doing well, then we are there to take care. So that guarantee is provided by whom? That guarantee is provided by this code. How? That is, if it is a going concern company, if the liabilities are more, then we will undergo or give an opportunity to you so that a third party comes in and takes over your company. Somebody else comes in from the market and reorganizes your company. So when this boosting up is there, when the fear is not there, definitely the creative minds in India will come up with startups, will come up with entrepreneurship, and the economy will boom. So again, this code has a direct link with the economy of the country. So it is also said to be an economic legislation. Why? Because once the company has started, has been incorporated, so it is not going into liquidation. Rather, we are thinking about reviving the company. And when we are thinking about reviving the company, definitely there is a boom in the market. There is a boom with the international stakeholders also. The growth is there. So again, it also talks about the credit availability of the creditors in the market. So one very important thing that need to be taken care is that it is also a creditor centric regime. This particular legislation is said to be creditor centric, whereas prior to 2016 it was a debtor intrinsic those were debtor intrinsic legislations. So what is the difference between debtor intrinsic and creditor centric? Creditor centric meaning thereby that the creditors are protected. So if at all the creditors are protected, then only the availability of credit will be there in the market. Mind it, creditability. If you could just mute your mic, Ansha Gupta. So, a creditor centric meaning thereby that is the creditors will be also protected with respect to whatever the credit they provide to the business people, to the corporates. For example, the banks, if they are providing loans to whom? To the debtors, they also need to be protected. That is, yes, I have given you loan. If at all you are secured, fine with me. But if at all you are not secured, then some security should be there that I will be protected, and next whosoever comes for the credit, I will be in a condition to provide the credit to them. So that is how they are also intending to protect the creditors. That is why it is creditor centric, and it has been stated in the very objective of the code that is, apart from promoting entrepreneurship, availability of credit and balancing the interest of all the stakeholders in the order of the priority of the payment of the government dues, and to establish an insolvency and bankruptcy board of India, and for matters connected therewith or incidental thereto. Meaning thereby that the code has taken effort to protect the interest of all the stakeholders. All the stakeholders, meaning thereby it is not only about the secured creditors, but it is also about the unsecured creditors. It is also about the environment. It is also about the government dues. So one particular section, that is section 53, talks about waterfall mechanism. What is that waterfall mechanism? It's nothing but a priority list in which they will be paid. So once the resolution plan that is made by the resolution applicants, in that particular resolution plan, it has to be stated that apart from the secured creditors, all the other creditors or whosoever has dues, right, they will also be paid according to the priority list. So that is why it has been stated in the very objective of the code, that is balancing the interest of all the stakeholders, meaning thereby that the code has not only taken care of protecting the corporate debtor, that is the CD. Apart from that, the creditors also are protected, right? So it is a balance between the CD and the creditors, and also the other stakeholders. For example, the government dues are there, the employees are there in a corporate world. So the employees, if at all the statutory dues are there, so whether they will lose because the company is under insolvency, they have been very well spoken of in the very objective of the code. Also, they have a regulatory authority which is established through this code, that is again called as the code. That is nothing but the Insolvency and the Bankruptcy Board of India. So, regulatory authority is IBBI, and the adjudicating authority, time and again you will find that in the provisions they are talking about the adjudicating authority. So who is the adjudicating authority? It is the National Company Law Tribunal, NCLT, and NCLAT, that is the appellate tribunal, and the appeal moves from NCLT to NCLAT and thereafter the Supreme Court. So this is all about the IBC, the entire corporate insolvency resolution process that is there under the new code. Now, the definition clauses are there, but again, if you look into section 7, section 8, 9, and section 10, which are said to be the very crux of the code, that is, who can initiate, whether myself, whether the participants, if you think of that, yes, we have views and we can initiate CIRP, right? So section 7, 8, 9, and 10 provides as to who can initiate the CIRP application. So section 7 talks about, again, the financial creditors. Financial creditors, and section 8 talks about operational creditors. So the basic difference, now there are two types of creditors under IBC which you will not find under Companies Act. Companies Act generally deals with secured creditors and unsecured creditors, but here under IBC we deal with two types of creditors, that is the financial creditors and the operational creditors. So section 7 talks about the financial creditors initiating CIRP, whereas section 8 and 9 talks about the operational creditors initiating CIRP, and section 10 talks about that the debtor, which is again a very peculiar section as to why the debtor will initiate CIRP application for against himself, right? But again, if the intention is bona fide, then they are also given an opportunity to initiate a CIRP application. So what is the basic difference between the financial creditors and the operational creditors? Generally, the financial creditors, 99% of the financial creditors, they are generally the secured creditors, the financial institutions. So, two tests are to be determined for coming under the heading of financial creditors. One is the court, the NCLT has to, sorry, not the court, but the tribunal has to look into this content. That is, whether time value of money is there in that particular transaction or not. And the second thing would be commercial effect of borrowing, whether that content is also there in that particular transaction between the debtor and the creditor. If at all both the things are present, then they are said to be the financial creditors of the corporate debtor. And the entire procedure is stated under section 7. as to how they will initiate the CIRP applications, what particulars are to be annexed along with the application. Obviously, the threshold which is provided under Section 4, that is again 1 crore. So the debt amount that has to be more than 1 crore or more. So then only CIRP application can be initiated. So earlier it was 1 lakh, but then through the amendment, again in the pandemic 2020, it has been increased to 1 crore. So again, when we are talking about the operational creditors, Section 8 and Section 9 deals with the operational creditors. Now, who are these operational creditors? Now, for a company, it is not obviously and every time important that if at all loans will be provided, then the company is ready to operationalize its business. No, that is not the way out. So, goods and services are also required for the operationalization of the company. So, who will provide the goods? Who will provide the goods and services? So, these people who provide the raw materials, who provide the services, it might be an individual, it might be an organization, a company, right? So they are again the operational creditors who are actually providing the raw materials to the corporate debtor for operationalizing its business. Again, this is very interesting. That is, there are a whole lot of cases from 2016 onwards, that is from the when the code has been enacted, stating that why financial creditors and operational creditors are not at par. So why again more power has been given to financial creditors and why less power has been given to operational creditors. So Swiss Ribbons versus the Union of India is a landmark case with respect to this, whereby Section 7 has been constitutionally challenged before the Supreme Court, stating that there has been violation of Article 14, equality. But then, if you look into the very logic of the financial creditors and the logic behind the operational creditors, you will find that yes, the very nature of transaction of a financial creditor with a CD is very different from an operational creditor with a CD. Why? Because, for example, a financial institution, for example, bank, obviously when it provides a huge amount to a CD, it gets many documents, many evidences, proofs as to know about the whereabouts of the company, how the company has been established, who is the hidden face behind the company, uh, who all are the creditors, who all are the stakeholders. Every bit of information is there with the operation, is with the financial creditor. So the very nature of transaction between a CD and a financial creditor is said to be very strong. Whereas in case of an operational creditor, it is a relationship which might be based on faith, might be based on trust. That is fine. We are lagging behind 2 tons of steel. So there is a telephonic conversation to the supplier that everything, the production is done, but please provide me with 2 tons of steel. And there is no documentation, nothing, and the supplier provides the raw materials to the CD. There is no proof. The amount has not been paid, right? The supplier even does not know who is actually behind the company. So this is the major difference between a financial creditor and an operational creditor, because of which the code has given them different powers. It is not that one is kept above the other. Obviously, they are at the same pedestal, because the very nature of transaction is very different of a financial creditor with the CD and an operational creditor with the CD. So this is one point which has been raised in many of the cases, Swiss ribbons being one of them. And finally, in the SR Steel, a very landmark case of 2019, to some extent it has been settled. So, under Section 9, an operational creditor can also initiate an application, a CIRP application. And Section 10 deals with that a corporate debtor himself can initiate a corporate applicant. The word here is corporate applicant. Who is said to be a corporate applicant? Again, it can be CD, it can be anyone who is authorized by the CD, it can be a person who has the control over the financial affairs of the company. So all these persons are said to be acting on behalf of the CD, and again, there is a threshold. That means a special resolution need to be passed by the board. Thereafter, they can initiate a CIRP against themselves. So this is one peculiar section which is very interesting, that apart from the creditors, if the debtor also wants that, they want to revive the company because might be they could not perform the works well, they could not operationalize the business, so they were not able to obtain profit. So what next? The company is not going to liquidate, they want the revival. So Section 10 has given them a shield as to revive the company. One more important component which need to be known is the moratorium period. Now, moratorium, if you look into Section 14 of the code, is a very catchy terminology used under corporate insolvency resolution process. What is moratorium? This is not specifically given anywhere under Companies Act, but here moratorium again has a lot role to play under CIRP to protect the company, to protect the CD from going into liquidation. Moratorium is what? Moratorium is nothing but the cooling period, the breathing period, the calm period, which is provided to whom? Which is provided to the corporate debtor. Why is it provided? Because the company is a going concern company. It is a stressed out company. If you put more stress on the company, ultimately the company will collapse. We don't want the collapse. Why? We don't want to go into liquidation. What we want? We want to revive the company. So, the provision states that nobody would be allowed to initiate any kind of suit, any kind of arbitration, any kind of proceeding against the going concern company, against the corporate debtor. When is the moratorium? When the moratorium commences? Once the application is accepted by the adjudicating authority. Which application? CIRP application. Once it is accepted by the adjudicating authority, at that moment, that is called as the insolvency commencement date, from that moment the moratorium is declared. And thereafter, interim resolution professional is appointed and he makes an public announcement, that is to make the public aware that the company is undergoing insolvency. Whosoever have claims, whosoever have any dues, please submit your claims so that ultimately the claims are consolidated at a place and When the information memorandum is being prepared by whom? By the resolution professional, then all the claims are collected, are consolidated at one place, so that ultimately how much is the liability of the corporate debtor, that is made known to the third party who wants to take over the company. That third party is none other than the resolution applicant. So the moratorium again plays a very crucial role as to providing the corporate debtor that fine, you are already under stress. We are providing you again with an opportunity. You take rest for this period because we are not going to burden you with any more suits or proceedings. Whatever are there, those will be applicable. But then no further new suits or institution of suits or proceedings will be there against you. Now, why this moratorium provision is there? So that the assets of the corporate debtor are protected and preserved. If at all there are more suits, if at all there are proceedings, the valuation of the assets will get distorted. During this period, the transfer or the alienation of the assets are also not allowed by the corporate debtor. That means he cannot transfer it to anybody else. Why? These need to be preserved and protected because ultimately, from the valuation of those assets only, the disbursement of the amount will be there to the creditors. So that is again one very important thing which has been incorporated into the code, taking care of the protection of the assets of the corporate debtor. Next, what are the duties? What are the powers given to the IRP and the RP? Who is the IRP? It is the interim resolution professional. So under the insolvency resolution professionals, two bifurcations are there. One is at the temporary level, that is before the constitution of the COC, interim resolution professionals are there. And after the COC gets constituted, maybe the same IRP is appointed as the RP or some other resolution professional will be appointed as the RP. So they again are responsible for the entire conduction of the CIRP. They are said to be the facilitators. They are said to be the middlemen between the various stakeholders of the company. They are responsible for receiving the claims. They are responsible for collating the claims. They are responsible for framing the information memorandum. And also, they are responsible for the essential goods and services and critical goods and services. If at all some payments need to be made, then if the COC is not constituted till that time, then the IRP will have to pay the expenses. Obviously, after the CIRP is over, they will get the reimbursement, but then till that time, the major decisions will be taken by the IRP. That is, once the COC is not into picture. Also, once the moratorium is declared, the powers of the BOD or the BOD you can say will get suspended, meaning thereby now this IRP will act like a BOD. Major decisions may also the execution of the documents on behalf of the BOD will be done by the IRP and the RP. So this is one very a crucial role being played by the IRP, and after the constitution of the COC, the RP. Also, there are provisions which have expressly stated that the personnel of the CD have to cooperate with whom? Have to cooperate with the IRP as and when required. If at all there is no cooperation, then the IRPs can also make an application to the NCLT stating that these personnel are not cooperating with me, and accordingly the NCLT will give directions that no, you have to cooperate. So the logic behind this particular provision being stated very expressly is that the BOD has a whole lot of powers, and once power is gone, then they would not like to share the information with anybody else. How are they even involved? So expressly it has been taken care of by the legislature, that is, whosoever have the information, they have to provide the information to the IRP for the proper conduction of the CIRP, because ultimately it is related to the economy of the country. And thereafter, again, the important feature of this code is the COC, Committee of Creditors. So, who are there in the Committee of Creditors? Committee of Creditors generally, it is all the financial creditors who will constitute the COC. The operational creditors are also part and parcel, but one difference with regard to FCs and OCs are that financial creditors are given voting rights. Not only mere power of participation, but also voting powers are given to financial creditors, whereas operational creditors do not have the voting power. So this is also one point of tussle, because of which they have moved before the Supreme Court time and again. So the Committee of Creditors is responsible for taking all the decisions of for conducting the CIRP, and whatever the resolution plans are submitted to the resolution professional by the resolution applicants. At the first level, those are scrutinized by the resolution professional, and whatever the best plans are there, those are forwarded to the COC, and ultimately the best one is chalked out by the COC, Committee of Creditors, and finally the resolution plan is approved by the COC, and thereafter once it is approved by the COC, then it moves before the adjudicating authority, that is the NCLT, and finally the NCLT gives the approval, and once the approval is given, then the CIRP comes to an end, the moratorium also comes to an end. So once the CIRP comes to an end, meaning thereby it is a successful CIRP, but if at all because of any reason, for example, the resolution plan was not up to the mark, or the resolution plan has not been submitted, or for any, if the CIRP fails for any other reason, then the ultimate resort, or you can say the last resort for a company, would be going into liquidation. So that again is a different chapter altogether. So basically, CIRP was all about these intricacies dealing with the financial creditors, the operational creditors, the moratorium provisions, the duties of the RP, the constitution of the COC, and thereafter the information memorandum being drafted by the resolution professional, and finally the resolution plan being submitted to the COC, and thereafter the adjudicating authority. So that ends up with the corporate insolvency resolution process. Hope you have understood. It was very nice talking with the participants about a major fall that has taken place in the economy, and which in the very first 4 years was doing exceptionally well. But again, if you talk to the practitioners in NCLT as of now in 2025, they would be talking about that a lot of delays are happening, because of which Again, the IBC might again face the same fate as the earlier insolvency laws, but then we have an important amendment of 2025. It is till date a bill, but then looking into all these delays and time being the essence of IBC, many major changes have been there in the amendment bill of 2025. So please have a look with respect to all the amendments and specifically talking about the 2025 bill, and then you will understand that in the near future, IBC definitely is not going to get down, but will be above the other legislations with respect to protecting and preserving the valuation of the assets of a company. Thank you.
Thank you so much, ma'am. On behalf of Nyaya Shastra, I would like to extend our heartfelt gratitude to you, ma'am, for taking the time to be with us today. Thank you, ma'am, for your generosity in sharing your time and experience. Now, moving forward, let me first introduce Nyaya Shastra to you all. Nyaya Shastra aims to be a key hub for promoting legal excellence through a combination of research, teaching, raising awareness, and encouraging healthy competition. We are committed to advancing legal knowledge and creating a community that includes legal enthusiasts, scholars, professionals, and students. Our goal is to create a dynamic environment that fosters the growth, innovation, and excellence in the legal field. Ultimately, we want Nyaya Shastra to be a leading platform that bridges the gap between academic and practical law, combining research, education, and awareness. Nyaya Shastra organizes various competitions such as judgment writing, drafting, moot court competition, article writing competition, and conduct webinars. For more information, you can visit our website nyayashastra.co.in or follow us on Instagram nyay_shastra. You can also connect us through LinkedIn. With this, I Anjali Kumari, your host for today's program, in signing off from today's webinar. Thank you so much.